Good morning, friends. Today we are going to continue the total lecture in a real world situation, and we will see how the real world. This is a real world is basically creates or give incentive to people. So this is nothing in that sense is very strange to talk about actually the total real world. So far in the last so far or till in the last lecture, what we dealt under the tort case is actually setting the standard of care and how precaution as well as activity level been formed based on that, and theoretically all that has been given, and the things uh, will go smoothly, and that is a very important intention as far as learning is concerned. So based on that we had seen which one is better, and now let us go and see in the real world analysis, and how far it is uh, been followed is the most important question. So this lecture is largely focusing on this matter, analysis of tort in the real world. Okay. So Gary Schwartz's reality in the economic analysis tort law, does tort law really deter? Question. This is a paper which was written a couple of years back, and in that paper what they were dealing with is actually reviewing a wide range of empirical studies. Finds tort law does affect people's behavior in the direction the theory predicts. So, but not as strong as the model suggests. So, of course, there is always this tort has a positive effect on life, but not as the theory says. So, this is the observation from the paper. Most academics either took the model literally or pointed out reasons why model was strong and liability rules might not affect behavior at all. So, for Schwarz, the truth is somewhere in between. So this is what is the most important. And in Indian context also, we have a paper which is a very nicely written paper by Ram Singh of Delhi School of Economics. And he has a paper which is talks about accident, especially, and he was controlling all the variables in the variable on accident, and see that whether the rules were been the three rules normally applies in the accident cases to give compensation been met. So very interesting paper, and if you possibly you can actually look at it on that, so to understand the flair. Anyway, I'll talk about that paper also a little later. So let us first concentrate on what is Gary Schwartz says in the paper. Here between the economist's strong claim that tort law systematically deter, and the critic responds that the tort law rarely, if ever, deters, lies an intermediate position. So tort law, while not as effective as economic model suggests, may still be somewhat successful in achieving its stated deterrence goal. The information related studies that suggest that the strong form of the deterrence argument is in error, yet it provides support for that argument in its moderate form. Sector by sector, tort law provides something significant by way of deterrence. Now, much of the modern economic analysis then is a worthwhile endeavor because it provides a stimulating intellectual exercise rather than because it reveals the impact of liability rules on the conduct of real world actors. Consider then those public policy analysts who, for whatever reason, do not secure enjoyment from a sophisticated economic proof, who cares about the economic analysis only because it might show how tort liability rule can actually improve level of safety in society. These analysis would be largely warranted in ignoring those portion of the law and economics literature that aiming at the fine tuning. So workers' compensation rule in the United States, for example, where being discussed an employer is liable whether or not he was negligent for economic cost of on the job accidents, right? So the victim still bears non-economic costs such as the pain and suffering, etc. So workers' compensation disavows its ability to manipulate liability rules so as to achieve in each case the precisely efficient result in terms of primary behavior. No, later, I in the when a couple of lectures back, I said this same point, talking because of a very different thing. Because now the concerns of the courts are now moving towards this sort of a feeling, or kind of the non-economic, the non-pecuniary costs which is people are having due to some sort of negligence or unreliable accident. So unless and until we give priority in this matter, it is difficult the compensation just or not. So to assess the compensation as just or something efficient. So it accepts as adequate the notion that if the law imposes a significant portion of the accident loss on each set of parties, these parties will have reasonably strong incentive to take many of the steps that might be successful reducing accident risk. So this observation is very important as I pointed, the Ram Singh's paper is also talked about in the similar line. The paper was actually, for example, to understand where even the code, under the same law, whether the code follows the same rule or ruling across the state was the concern. It is, as a fact check made in the paper, and the paper was a controlled environment of the age of the this is actually the state transport overrun case and death case. So there is an accident, and that accident is caused by state department, the state transport corporations, and the age of the accident, that is the victim, is controlled like same age, and the gender is again controlled, and then yes, then so the age, gender, and the year is also checked. So the same year, same age, almost same age, and then gender is the same. And then the paper was looked at how different court had ruled in favor of against the victim. So this is what was actually the paper was trying to do. And in India, if India means you have only, I mean, all this case were being under the same law, right? Because the whichever. So very exciting observation with the paper had brought out that in different rulings, the compensation amount varies from a very paltry amount to a huge amount. So even in this case, so that means the court has the setting of legal standard of care, and even awarding compensation, etc., is not necessarily follows the same rule at all, even if it is the same rule and the law which we claim for. But there is a very exciting observation, because this is what we have to actually carry forward. We have to check whether this is happening, and what is whether this is the case or not should be our concern, and then we will see that what effective mechanism which we can develop to mitigate the problem. Just like the paper which is Gary Schwartz was talking about. So far, this is about the paper, and there are so many work which we can conduct based on this different aspects. So our model this far has assumed that people are rational. Why this change has happened? So this is what is the concern. So the paper is always given priority to rational people. Injurious pay damage in full. There are no regulation in place other than the liability rule. There is no insurance, litigation costs is costless, etc. So most of the case, what we have seen in our own study, is actually the cost of the litigation is huge across the country, and we can think about would happen when each of these assumptions is being violated? Suppose if the rationality condition is violated, behavioral economics talks about these things, right? So people systematically misjudge value of the probabilistic events. Daniel Kahneman and Amos Tversky's the prospect theory and analysis decision under risk. That is 45% chance of $600, sorry, $6,000 versus 90% chance of $300. Most people, that is 86%, chooses the second, right? So 1% chance of 6,000 versus 2% chance of 3%. Most people, that is 73%, chooses the first. All right. Now, but under expected utility, either, that is your u 6,000 is less than to you 3,000, so, or it is not. So people don't actually seems to maximize expected utility. This is a complete criticism against the expected utility approach by von Neumann and Morgenstein, and the behavior is actually completely different to that of the expected utility. But economic understanding is largely depends on this expected utility, and the error have to do with how people evaluate probability. Now, so this is what, when you can say the rationality assumption, though we make, that rationality is also having a sort of connection and dependency on how people take it. Okay, people seems to overestimate chances of unlikely events well with the publicized catastrophic events. The paper book of economics, people fixated on exotic unlikely risks rather than more commonplace one that are more dangerous. All right. So how to apply this? Accidents with power tools could be designed safer, could be used more cautiously. Suppose consumer underestimate risk of an accident, then negligence with the defensive contributing negligence. We see that it would lead to tools which are very safe when used correctly, but would lead to too many accidents when consumers are irrational in that context. So strict liability would lead to products which were less likely to cause accident even when used recklessly. So this is what we have seen. See, the precaution level and the activity level difference which we have seen in different rules earlier precisely reflect this fact. That is, if you take precaution higher, then your activity level will be too high, and the result is you have too many accidents, probability of too many accidents in that context. So let us so this is what is actually the fact check normally we keep in mind. And in the assumption second one, that is injurers pay damage in full assumption, normally strict liability injurer internalizes expect harm done leading to efficient precaution. But what if harm done by is 1 million, injurer only has 1 lakh, so injurer can only pay 1 lakh. But if the anticipate this, he know that is your D is very less than A, so he doesn't internalize full cost of harm, so he takes inefficient level of precaution. Injurers whose liability is limited by bankruptcy is called judgment proof in that sense. So this problem we have already seen, and this is a very widespread thing. So example of judgment proof is owner of an oil tanker. Suppose any accident would be an environmental catastrophe doing say $50 million of harm. Upgraded navigation system would cost 2.5 lakhs, and reduced likelihood of an accident of 1 by 100 to 1 by 500. So precaution reduces expected harm from say 50 million to 1 lakh cost, then the cost 2.25 lakhs. So efficient to take precaution. If company would be forced to pay 50 after an accident, then unrestricted liability would choose to buy new navigation system. Suppose the business is only worth of say 5 million. If there is an accident, pay 50 million, go out of business. Now navigation system reduces expected damage of $50,000 to 10,000, not worth the cost which they are. So judgment of the business would take too little precaution. So this is very important. And what stops me from speeding? That is another question. So now, assumption is that there is no regulation. Now, that is also going to have an effect which is very, very important. And for example, the speed. So what stops me from speeding? So if I cause an accident, I'll have to pay for it. Even if I don't cause an accident, I might get a speeding ticket. Similarly, fire regulations might require a store to have a working fire extinguisher. So regulation applies additional incentive to take precaution. So it is not because I don't like speeding. What I'm trying to say is not because I don't like speeding, but because of the regulation exists, that I'll be very much careful. Okay. For example, in the age limit we used to see in the country, in our own state or nation, that the youngsters are actually having very high speed riding. Not all, but some. But at the same time, the elders also having the same issue. Some are very fast, some are very slow. What does it mean? It means nothing, in fact, because some people value the regulation, therefore they ride slow. Some people don't value the regulation, therefore they. But if there is no regulation, everybody would do the other thing. But still, people are not doing it. So there is a lot of such issues. Even during the time of COVID, we are in the midst of the pandemic. Roads are empty, but most of the time people are not driving so carelessly. But some drive carelessly. See, so with the traffic jammed situation, also some people drive very carelessly, but most of the people are not. So the regulation is actually playing it is kind of creates a sense of a different incentive in that sense. So supplies, that is what it supplies definitely an additional incentive to take precaution. When liability is greater, injurer's wealth liability does not create enough incentive for efficient precaution. So regulation which require efficient precaution solve the problem. So regulation also work better than liability when accident imposes small harm on large group of people. So this is also we have seen. Then let's talk about the fourth assumption, that is no insurance. So we assume injurer or victim actually bears cost of accident by themselves. When injurers or victim has insurance, they no longer have incentive to take precaution, right? But insurance tends not to be complete. Insurance reduces incentive to take precaution, and that creates a moral hazard problem. So insurance companies have always reduced moral hazard, deductible, co-payment, etc. So increase premium after accident. Insurance may impose safety standard that policy holders must meet, etc. So the real situation gives different incentive. And then the final one is the litigation cost is zero or nothing. But if litigation is costly, this affects incentive in both direction. If lawsuits are costly for victims, they may bring fewer suits. Some accident unpunished implies less incentive for precaution. But if being sued is costly for injurer, they internalize more than the cost of accident, so more incentive for precaution. So an example from Prolin's case, an introduction to law and economics. I hit you with my car. I did 10,000 worth of damage. We both know I was negligent, but courts are not perfect. So if we go to trial, 80% chance I'll be found liable, 20% I won't. So if I am held liable, damage are correct correctly set like 10,000. So an average, if we go to trial, you expect to recover 8,000. So but if we go to trial, we both have to hire lawyers. Suppose this cost each 3,000. Now your expected gains from going to trial is 8,000 minus 5,000, and my expected cost is 11,000. So why does costly litigation matter? This is a classic case. So why under strict liability, we said injury is internalized cost of accident, which implies efficient precaution, but this assumes cost of being sued is equal to damage done. Now, if courts are unpredictable and the litigation is costly, private cost of being sued for damage could be greater than or less than cost of accident, which could lead to too much or too little precaution. But also, if we can't settle out of court and cases go trial, then social cost of an accident include both the harm done and the resource expended during the trial. If trial is 6,000, then social cost of the accident isn't 10,000 but 16,000, which increases the efficient level of precaution. So this is all the problem which we no, then we'll move on to the issue of what is life worth. Assessing damage in a wrongful death lawsuit requires some notion of what life is worth. Safety regulators also need some notion of what a life is worth. Kip Viscus is the value of risk to life and health is giving a very regulation, airplane cabin fire protection. See, estimated cost is 2 lakh. Car side door protection standard is 1 lakh. 1.3 million. OSHA asbestos regulation, you have 89 million. EPA asbestos regulation, you have 104.2 million estimated per life saved. That is proposed OSHA. Formaldehyde standard is actually much above this much of cost. So decides where to draw the line. So this question is that in the example which I was talking about, that is the paper which I referred earlier, the Ram Singh's paper also talk. The value, the life which was being assessed by different courts across India is different, though the gender and the age etc. is the same, and the cost and the other party, that is the injurer, is also having similar characteristics, but they still the value of life is different for different people. For example, if I am flying, then 20 lakhs is my insurance. If I am in a train, it won't be that much. If I am in a bus, much less. So value of life is depend on different aspect in that sense. So what makes us to actually assess the real cost or benefit is, again, I'm opening it for discussion as well as further studies in different context. So let us go to the other point, the last kind of topic under tort law, which is called the vicarious liability. Okay, so vicarious liability is when one person is held liable for the harm caused by another person. So parents may be liable for the harm caused by their children. Employer may be liable for the harm caused by employee. Respondent, this is what is based on the responde superior. So let the master answer clause. This is very important clause which has been applied in this case of liability. So employer is liable for tort of employee if employee was acting within the scope of his employment. So this is most. If I am actually driving, if I am an employee of some institution, then I'm acting on behalf of the institute, and then that is going to actually be the liability of the employer himself or herself for themselves in that sense. So vicarious liability is very important. So vicarious liability can be implemented through strict liability rule, employer liable for any harm caused by employee as long as employee was acting within the scope of the employment. Negligence rule, employer is only liable if he was negligent in supervising employee. So which is better? It depends. That is, if proving negligent supervision is too hard, strict vicarious liability may be work better. But an example favoring negligent vicarious liability. Then this is what is we have seen the towing case. The example which I have given is talking about the vicarious liability. In fact, kind of. Now, joint and several liability. This is suppose you were harmed by accident caused by two injurers. Joint liability. You can sue them both together. Several liability. You can sue each one separately. Several liability with the contribution, which is only liable for his or her share of damage, and joint several liability you can sue either one for the full amount of the harm. Joint and several liability with contribution, the one who sued could then sue his friend to get back half his money. So joint and several liability holds under common law when defendant acted together to cause the harm or harm was indivisible, impossible to tell who was at fault, and good for the victim because no need to prove exactly who caused harm and a greater chance of predicting full level of damage. Instead of suing person most responsible, could sue persons most likely to be able to pay. Now, one problem with the inconsistent damage, that is more incentive to fight hard. Now, for example, each side can hire cheap lawyers or expensive lawyers. Cheap lawyer costs 10, expensive lawyer 45. If two lawyers are equally good, expecting judgment is 100. If one is better, expected judgment is doubled or halved. That is the kind of cheap and dear lawyers. Example, so if cheap lawyer did 9 minus 110, expensive 995. So expensive lawyer versus the cheap lawyer for both the plaintiff and defendant, this would be a kind of payoff. So what happens is that you will end up at expensive lawyer in a nutshell. So punitive damage is the other kind of problem with what we have discussed so far is compensatory damage, meant to make victim whole, compensated for actual damage done. So in addition, courts sometimes about punitive damage. Additional damage meant to punish injury, create stronger incentive to avoid initial harm. The Marlborough example we start with is a punitive damage, in fact, than the compensatory damage. So punitive damage generally not awarded for innocent mistakes, but may be used when injurious behavior was malicious, oppressive, gross, willful, and wanton or fraudulent. So punitive damage, therefore, calculation of punitive damage comes with different issues and even less well defined than compensatory damage. So level of punitive damage supposed to be a reasonable relationship to level of compensatory damage. No clear exactly what this means in them. So that is a problem. It is not clear at all. So US Supreme Court defines this as punitive damage more than 10 times compensatory damage will attract close scrutiny but not explicitly ruled out. So what is the economic purpose of punitive damage is the question immediately some can ask. We have said all along with perfect compensation incentives for injurer are set correctly. So why punitive damage? Example, suppose manufacturer can eliminate 10 accidents a year, each causing 1,000 in damage 90. Clearly efficient. If every accident victim sue and win, company has incentive to take this precaution. But if some won't, then not enough incentive. Suppose only half the victim will bring successful lawsuit. Compensatory damage would be 5,000. Company is better off paying that than taking efficient precaution. One way to fix this is award a higher damage in the cases that are brought. So, to wrap up the story, let's draw a story from Friedman. A tort plaintiff succeeded in collecting a large damage judgment. The defendant's attorney, confident that the claimed injury was bogus, went over to the plaintiff after the trial and warned him that if he was ever seen out of his wheelchair, he would be back in court on a charge of fraud. The plaintiff replied that to save the lawyer the cost of having him followed, he would be happy to describe his travel plan. He reached into his pocket and drew out an airline ticket to Lourdes, the site of a Catholic shrine famous for miracle. So this is how people are trying to deal with the situation. So thanks once again to all of you for listening it, and I hope that this lecture on tort is informative as well as enjoyable to all of you, and wish a good luck and thanks. And this much of the topic which we are covered in the tort. Thank you so much.